My name is Mitchell, and yesterday my colleague and I, David Bateman, did a presentation on the Endrew decision, which is, of course, the recent Supreme Court decision on special education, specifically on what is a free, appropriate public education. And what I wanted to do today is something quite different than what we did yesterday, and that is really focus in on what the Endrew decision had to say about behavior and addressing behavior. And it wasn't at the Supreme Court so much as it was at later stages of the Endrew case, which I'll explain. So there's quite a few implications of this decision for addressing problem behavior. I think the important thing we need to understand about the law is I believe it's not correct to think in terms of, oh, the law's going to get us, we have to watch out, we don't want to do this. The really important thing is it gives us lessons about what we need to do correctly and how it is that we goof up in educating youngsters with disabilities. And so that's the way I'd like you to approach this. This is not just warning, don't do this. This is the way we really should be doing things if we want to meet the requirements of the law. And the first thing I wanted to talk about is how the Individuals with Disabilities Education Act, when it was reauthorized and amended in 2004 in a law called the Individuals with Disabilities Education Improvement Act, which was just an amendment to the law. That name really did not change the name of the law, it's still the idea. But that was an amendment to the law in 2004. And there were some pretty significant changes made to that law, and a couple of them really affect behavioral programming. And I wanted to talk about those a little bit. In many ways, there was an increased focus on behavioral programming, especially with respect to kids with disabilities, with any problem behavior, not just EBD kids, or not just kids with behavioral disorders. For kids with any disability that also have problem behaviors are really affected by this law, this reauthorization, I should say, and the Endrew decision. And in many ways, the focus on IDEA was really on improving education. That's why the name of the law was the Individuals with Disabilities Education Improvement Act. And it focused very much on the behavioral issues. And it did so in a number of ways. Number one, in terms of the assessment that we do. And remember, when I talk about this, not just BD kids, it's all kids with disabilities. That we have to use a variety of assessment tools to gather relevant functional, developmental, and academic information. So we see for the first time in 2004 this term functional coming into the law. In terms of present levels of academic performance, when I was a teacher for many years in Minnesota, we just called those PLOPs or PLEPs, present levels of performance. Well, in 2004, they got a new name, and the new name was present levels of academic achievement and functional performance. And again, the new word functional showing up there. Measurable annual goals had to include academic and functional goals. That was right in the idea. And again, all of a sudden, this new word functional. So what did functional mean? What did Congress mean by that? Well, unfortunately, they never actually defined it. But in a later letter, a policy letter, in which they were asked, what do you mean by functional? This is what they said. They said functional refers to skills or activities that are not considered academic or related to a child's academic achievement. Instead, functional is often used in the context of routine activities of everyday living. The range of functional skills is as varied as the individual needs of students with disabilities, and the term includes behavior, which, if they interfere with the student's independent and functioning, must be addressed in the IEP. So functioning is a lot broader than just behavior, but it refers to those routine activities that are required for successful adjustment, successful everyday living skills, and behavior is clearly one of those skills. Now, I should say, before I get started, I'm going to refer to a couple documents. We just talked about the law. This is actually from a regulation, a comment to a regulation which is published in the Federal Register. I'll be talking later about some court cases, not too many, just a few. They are very important aspects of law, and then also about something called a Dear Colleague letter. Because when the law is passed by Congress, signed by the President, then Congress delegates so much of the authority to the regulatory agency in charge of education, which of course is the U.S. Department of Education, and they promulgate or write the regulations to the law, which actually can't go beyond the law, but they kind of fill in the missing pieces, because the law is actually seen as more a kind of a guideline, and then the missing pieces are filled in by the Department of Education in the regulations. Now, the Department of Education also has, in addition to overseeing the idea, they also have a kind of a regulatory function whereby if any of you folks are interested in, had a question about what does this mean in the idea, you could write them a letter, and they will quite likely write you back. And it might be, if Dale wrote him a letter, it might come back, a letter to Thomas, but it will be published. And it's really an open letter to anyone. It's policy guidance. And a lot of times, if they thought Dale's question was so important that they wanted everybody to know it, they will address it Dear Colleague. So Dear Colleague letters come out all the time. And they're what the Department of Education is trying to tell us. This is, administrators, teachers, this is how you need to implement. This is what we meant by functional behavior or anything like that. And so I'll be talking about some Dear Colleague letters too. And any of this new handout or the PowerPoint slides which I'm doing, which are on the jump drive that you were given, I've added a few things in there, so if you'd like any of them again, I'll be happy to send it. I also have a ton of these Dear Colleague letters, not a ton of them, a lot of them that I think you might be interested in. So if you find anything you're interested in when we talk, please just feel free to email me, and I'll be happy to answer. So functional all of a sudden turns up in 2004. And then this also turns up, and this is very interesting, what happened with this. But in a section of the idea on IEPs, the new idea 2004 included this information. If a student's behavior impedes the child's learning or that of others, the IEP team must consider the use of positive behavioral interventions and supports to address that behavior. Well, that seems simple enough. That's one of those 5 extra category type things. And they're saying basically with any student with disabilities, regardless of what their disability label is, if their behavior impedes their learning or the learning of others, the IEP team must consider the use of positive behavioral interventions and supports to address that behavior. Well, come 2017, there was a case that I talked about yesterday. I'm not going to talk about it again today, but Endrew v. Douglas County School District. Well, this involved a young boy named Drew who had autism and ADHD. He lived south of Denver, Colorado. He had a measured IQ of 80. He had a lot of problem behaviors. He was educated from preschool all the way through 4th grade in the Douglas County school system. And in his 4th year, his parents went to the IEP meeting and they said, we're really not very pleased with what's happening. Your IEP is essentially repeating the same thing year after year, and his academics are suffering, his behavior is getting worse, and in fact, his progress is totally stalled, and we want to rewrite this IEP to address these behaviors. And they were really mostly concerned about the behaviors. In a realistic way, we want you to do a functional behavioral assessment, we want you to write a behavior intervention plan and all this kind of stuff. Well, the school said, yeah, that's important. So they wrote an IEP that essentially repeated the last IEP. goals are the same, the objectives are the same, no real difference. And so what the parents did is they, as they have the right to do, asked for a due process hearing. They are the dispute resolution of the idea, or Article 7. By the way, everything I'm talking about also is in Article 7 of the Indiana Code, so that applies too. They asked for their rights to have a due process hearing. They went to a due process hearing officer in Colorado, which is called an administrative law judge, and they heard the case. And basically the parents were saying, our youngster is not receiving a free appropriate public education because his academics are bad, but really because they're not addressing his behavioral problems. And well, at the time, Colorado was in the 10th Circuit, which if you were there yesterday, we said that is a circuit that has a really low standard of what is a free appropriate public education. It's really quite low. And the administrative law judge looked at the Endrew case. And yeah, Drew wasn't doing very well. His behaviors were worsening. He wasn't really making any academic gains at all. But he said, according to the standard I have to use, and which all the due process hearing officers had to use in the 10th Circuit, he said, well, that's such a low standard that the school district did deliver a FAPE. They did provide him with a free appropriate public education. So what the parents did is something a lot of parents do. They chose to unilaterally move Drew to a private school. And this private school in Denver was called the Firefly Autism House. It was a school specifically for students with autism, and it was very expensive. Tuition was $70 grand a year. And they moved Drew to this school. And one of the reasons they did so is because the school had a very structured behavioral system to address Drew or any of their students' misbehavior. They had behavioral expertise on staff. They conducted functional behavioral assessments, wrote, in essence, their version of IEPs based on this functional behavioral assessment. But nonetheless, the administrative law judge said they met this low standard, so he decided in favor of the school district. Well, what happened is the parents then appealed in 2014 to the U.S. District Court for the District of Colorado. That's the first level of federal district courts. Every state has between 1 and 4 district courts. Colorado has 1. You have 2 in Indiana. And so the parents appealed the decision from the state review officer to the district court, and the district court looked at it, and basically what he had to do was look at the decision, look at the services Drew was receiving, and then the law, and decide, was Drew receiving a FAPE? And he decided, his name was Louis Babcock, that yes, the school district prevailed because he had to use this real low standard, and so he decided in favor of the parents, or excuse me, the school district. Then, undaunted, the parents appealed to the U.S. Circuit Court of Appeals for the 10th Circuit, which is a huge circuit. So it's all those states surrounding Denver. And when the circuit court says something, that's like right under the Supreme Court in terms of importance. So they took this case and they decided in favor of the school district because, again, they had this really low standard. Now, I'll kind of stop here and go back to what happened next, but I want to just tell you a little bit about Endrew in the circuit court. The 2 areas that the parents, Drew's parents, alleged that the school district failed to provide FAPE to Drew was with respect to their behavioral programming. The Douglas County School District, the parents asserted, failed to conduct a proper assessment of Endrew's problem behavior, and they didn't address it in the IEP. In fact, they said, although the school district disagreed, that there was no real mention of an actual behavioral program in the IEP at the time. So they said, that's the big problem we had here. Well, it went to the circuit court, and of course, this is a FAPE case. And because they had placed Drew in a private school, anytime a parent does that, they certainly have the right to unilaterally take their child and place them in private school, but they do so at their own risk. Because if they want to recoup the tuition, they have to go to court. And they have to get a court to agree to 2 things. One thing is that the school district has failed to provide FAPE. And the other is that the new school had done a good job. They had essentially provided a good program. Well, the court said Firefly Autism House did a bang-up job. They did a great job. But that's not the issue. The issue is, number one, they have to decide, did the school district provide FAPE? And they had that low standard, and they said, yes, the school district did provide FAPE. So they decided in favor of Drew, and although they said this case was without question a close call, which is really something because they had such a low standard for proving if a free appropriate public education had been offered, that they used this FAPE standard that the Solicitor General for the United States said a school will prevail if they provide services that confer about nothing, a little more than nothing in terms of educational benefit for a child. A very, very low standard. And of course, again, they were really looking at the behavior. Now, here's what they said about behavior. And this is kind of one of those statements. They came out with two statements that I would think would make any educator think, what on earth were they thinking of? They said, even though the record established that Drew is a child whose behavior impedes the child's learning or that of others, all that is required by the idea is that the district consider behavioral interventions. The record is filled with examples of the district's consideration of Drew's behavioral issues. Thus, the district complied with the law. Why? Because they considered it. They didn't put it in the IEP, but they thought about it and they talked about it. So that, according to the circuit court, met the requirements of the law. You see what a horribly low standard that is? That if we know a child has problem behaviors and we discuss it and we say, well, that's all we need to do, consider it. Because what this court did is they actually cited a legal scholar named Perry Zirkel, who wrote in a 2011 article that the pertinent terms in the IDEA sections on the use of behavioral interventions is to consider, not to develop or implement, but to consider. To meet the FAPE standard, thus, the 10th Circuit said they had considered it. They had considered behavior. They didn't do anything about it, but they met the requirements of the law by considering it. That's kind of a ridiculous statement. I mean, what educator would say something like that? And then they came out with another statement, was just as obnoxious, and that is to meet the FAPE standard of the 10th Circuit, the education provided to Drew had to merely be more than de minimis. De minimis is a Latin term meaning trivial. When it's applied to the courts, it essentially means it's so trivial that the court doesn't even have to pay attention to it. So they're saying if we as educators provide an education that provides a little more than nothing, that's all we need to do. And that was the question that went to the Supreme Court. And of course, the Supreme Court, as we talked about yesterday, in 2017 was only 8 justices at the time, because Justice Alito had passed away and they had not replaced him. And so those 8 justices heard the case, and this was a really important case. And the fact that there are only 8 justices could have meant it would have been a tie. It could have been a tie, could have been a 4-4 vote. If that happens, it's like the case never happened. And the decision would then go back to the 10th Circuit, which said we can have this real low standard, and we don't even have to address behavior. We just have to consider it. Well, of course, that's not what happened. All 8 justices unanimously decided that the 10th Circuit got it wrong, that the standard in the idea is much higher than that de minimis benefit. And interestingly enough, just to show you how much this decision really means, is the fellow that wrote that line, merely more than de minimis, formerly on the 10th Circuit Court of Appeals, a man named Neil Gorsuch, who's now in the Supreme Court. So you see how new people in the Supreme Court can really make a difference. Well, Justice Roberts has been a real friend of education, like, you know, you agree with him or not, he is a friend, has been a friend of education, and really took the court. I mean, these four, as we listened, it was pretty obvious that Alito and these five were really for this higher standard, and he got all 8 of them, so it was a unanimous decision. But essentially what they said, to meet their substantive obligation, under the idea a school must offer an IEP reasonably calculated to enable a child to make progress in light of the child's circumstances. So that was important, because up to then, the standard had been educational benefit. Well, some courts said, well, just a little benefit's all right. Like in Drew's case, he had actually progressed toward one of his goals when he was in 2nd grade, and they said that was enough. But the Supreme Court threw that out. They said educational benefit isn't enough. It must be progress. We must see progress. Now, so there was 2 main principles of Endrew. One is our children have to make progress. Our IEPs have to be reasonably calculated to enable a child to make progress in light of their circumstances. You could say make progress appropriate to their unique educational needs. And the second key principle is the individualization, that special education must be specifically designed to meet students' unique needs, and that includes in the area of behavior. Well, what they did is, and the Supreme Court will often do this, is they did something called remanding the decision. Remanding the decision essentially means that they said to the courts, we think you got it wrong. What you said previously no longer stands, and now you have to re-rule based on our new standard, which was that, progress. So they kicked it back. It went back to the United States Courts of Appeals for the 10th Circuit, which, remember, had that real low standard that merely more than de minimis was good enough. They said, well, no, you got that wrong. Now look at this new standard and re-rule. Well, remember, the 10th Circuit said this case was a close call, even though Endrew had, with the old educational benefit, so you can imagine it wasn't even close to it was not a close call anymore. But what happened is a few months later, the United States Circuit Court of Appeals for the 10th Circuit announced their decision on remand, and what they did is they kicked the can back down to the district court. They said, yeah, our old ruling doesn't stand anymore. We overturn it, but we vacate, but we remand it back to the United States District Court. So it went back down to the district court. So if we go way back here, Supreme Court vacated and remanded, went back to the circuit court. Now it goes back all the way to the 10th Circuit, which in 2018 took the case up. It's the same judge, Louis Babcock in Denver, that made this ruling, and he had to rule then, was the Drew case, what will happen with Endrew's case, even though I ruled against him first, I have a new standard to rule on now. And so what this district court judge, Louis Babcock, did is he reversed the decision that he made and the administrative court made, denying Endrew and his parents' request for a reimbursement. So he said, in essence, school district, Douglas County School District, you did not provide FAPE. Parents, you chose Firefly Autism House, and they had a pretty good program. So school district, you owe them tuition reimbursement, and you owe them reasonable attorney's fees. Well, as I've often said, there's nothing reasonable about attorney's fees going all the way to the Supreme Court. So what happened is the parents and the school district got together, decided on a final settlement after 7 years of litigation. Drew was now a senior, or not a senior, but now he's a senior. The Douglas County School District paid $1.3 million from the district's general fund to settle the case. Now, what is really important there is not that we need to, as Whitaker said, it's not that we need to focus on parents suing in future cases. What we need to focus on is what can we learn from this? What can we ensure that we do right so these kind of things don't happen to us? Well, when it went down to the district court, the district court really tackled this issue that had, really vexed everyone, and that was what's going to be done about Drew's behavior, about his escalating problem behaviors. So what does this decision mean for kids with behavior problems? Well, it means a lot, and this is why. This is what I think. It's clear from this decision that if we look back at some of the language in the Endrew case, that if a student's IEPs do not address a student's behavior when necessary, remember the student's behavior must impede their learning or the learning of others, when that's not addressed, that may be a violation of FAPE. Now, we go back to what the idea said. In the case of a child whose behavior impedes their learning or the learning of others, consider the use of positive behavioral interventions, supports, and other strategies to address that behavior. Well, remember, the 10th Circuit focused on that term right there. They focused on consider. But that's not what happened when it went back on remand to the district court. Because this is the final issue, this is the issue that really caused the school district to lose. And that was, in the words of Louis Babcock, who wrote his decision saying, the district's inability to properly address petitioner's behaviors, that in turn negatively impacted his ability to make progress in his educational and functional goals, also cuts against the reasonableness of the April 2010 IEP. In other words, he was saying that was where they really got it wrong. They didn't address his problem behavior. And actually the school admitted that all along. We didn't do a very good job. But they said, but we did good enough job. And the district court finally said, no, you didn't. He's not a behavior, I mean, he was a child with autism, and he had problem behaviors, and they just didn't address them. And that was the basic reason that Louis Babcock ruled against the school district, because behavior problems were there, they didn't address them. Yeah, maybe they considered them, but that wasn't enough. They had to do something about it too, and they didn't. Now, the U.S. Department of Education has also weighed in on this. And I have a copy, I'll be glad to send anybody this. They wrote what's called a Dear Colleague letter, which I explained to you was a letter written, it's an open letter to anyone, but it's physically sent to all the superintendents in the country, and they had a letter just on addressing behavior in students' IEPs. And what they said right at the beginning of the letter is the failure to consider and provide for needed behavioral supports through the IEP process is likely to result in a child not receiving a meaningful educational benefit in FAPE. Now, this, by the way, was written before Endrew. And so they probably wouldn't use meaningful educational benefit because now the word is FAPE, or the word is progress, the key word in the Supreme Court's decision. So that means, in essence, if we have a child with problem behavior and impedes their learning or the learning of others, we need to address it in the IEP. And failure to do so will probably mean that we're not addressing a child's functional needs and also impacting their academics. Because if they behave in a way that they are not learning, that clearly is not only a functional problem, then we have an academic problem too. Now, another interesting thing that the Department of Education said in the Dear Colleague letter is that research shows that school-wide small group and individual behavioral supports that use proactive and preventive approaches address the underlying cause of behavior and reinforce positive behaviors are associated with increases in academic achievement and fewer suspensions and dropouts. Now, at this conference, you've all heard of PBIS, Positive Behavior Intervention Supports. Essentially what the Department of Education was saying before they got even to the IEP section is you need to really consider in your school having a system of school-wide positive behavior supports, because that shows to address, reinforce positive, associated with increases in academic achievement and fewer suspensions and dropouts. So that was a way for the Department of Education to advocate for the inclusion of a school-wide positive behavior support program. As a matter of best practice, the department went on, we strongly encourage schools to consider how the implementation of behavioral supports within the IEP could be facilitated through a school-wide multi-tiered behavioral framework. So here again, the Department of Education is saying there is a lot of research out there that shows school-wide positive behavior interventions supports can be very useful. We encourage you to think of using them. And if you do, or if you don't, if a child experiences behavioral challenges, including those that can result in suspensions, you need to put appropriate behavioral supports in the child's IEP, because those may be necessary to ensure FAPE. Now, there have been a number of rulings out of OSEP, the Office of Special Education Programs, and the Office of Civil Rights in the Department of Education that has said one very important piece here is positive behavioral supports. There have been many rulings that have been negative towards school districts that just use punitive measures in their IEPs. Because what does the law say? It says positive behavioral intervention and supports designed to teach appropriate behavior. Now, also another important part of this are the supplementary aids and services that we provide to children, and the Department of Education addressed that, saying that in essence, if we have children with problem behavior, again, regardless of their disability, if they need behavioral supports in order to be educated in the regular classroom, in a more inclusive environment, such behavioral supports should be put in the section on IEPs on accommodations and modifications. And they may include things like meetings with a behavioral coach, social skills instruction, meeting with a counselor, or other approaches. But in essence, there's what the Department of Education was saying. In order to ensure that kids are being educated in those least restrictive environments, it may require that we use positive behavioral supports and actually put them in the IEPs as accommodations and modifications to be used in the IEP. Now, of course, if we have those in the IEP, that means we have to do them. Because whatever we put in the IEP, there was just recently a decision out of the Ninth Circuit Court of Appeals in a case called MC v. Antelope Hill Valley School. And essentially what they said, and this is a quote from the actual decision, the IEP is like a contract in that it is an agreement reached between the parents and school officials as to what will be provided. Now that's important, but it's also important to understand this distinction. The courts have never said the IEP is a contract that it guarantees success. What they've said, it's a contract in that we promise to provide these certain services, and we have to provide those. And in the last session, I talked about a decision out of West Virginia, where a social studies teacher in a school district was given an IEP that required him to read tests to his children, to one child in his class, and he didn't do that. And they wound up suing the school district and the parents, every member on the IEP team, the school board, and they sued him not under the IDEA, but under Section 1983 of the Federal Criminal Code, which actually makes it a criminal offense to knowingly violate a federal law. And the upshot was they said that the social studies teacher had knowingly violated the IDEA because that was in his IEP. He was supposed to do it, and he didn't do it. So it's very important if we use these accommodations and modifications, we put them in the IEP, including behavioral supports. We make darn sure they get delivered, that teachers understand what their responsibilities are and that they deliver them. Another important point that the U.S. Department of Education dealt with was placement issues. And here's what they said about that. In general, placement teams, or IEP teams, whoever makes the placement decision, may not place a student with a disability in special classes, separate schooling, or other restrictive settings outside of the regular education environment, and this is important, solely due to the child's behavior when behavioral supports through the provision of supplementary aids and services could be provided for that child that would be effective in addressing his or her behavior in the regular ed setting. So in other words, what they're saying is, if we're moving a child, if a child's in an inclusive setting, and we believe as an IEP team that that child's needs can be met through behavioral programming and supplementary services in the general ed setting, we have to put them in the IEP and we have to apply them. We have to make certain they're implemented as we write them in the IEP. So that's what the Department of Education said. Now, there have also been some very important cases that have addressed this very same issue. And the important thing is we can learn from mistakes that school districts make when they lose. This was a case called Neosho School District v. Clark, an IEP for a young man named Robert Clark who had behavioral problems and learning problems, was denied a free appropriate public education because the IEP did not appropriately address his problem behaviors. No cohesive plan was in place to meet Robert's behavioral needs, and that supports the ultimate conclusion that he was not able to obtain benefit from his education. That was back in 2003 under this lower standard. Under this new higher standard, this would be much more likely that if a school doesn't address student behavior, that could lead to a denial of FAPE, and that's exactly what the Department of Education said. Second main thing we have to understand about the Endrew decision is that educational benefit standard requires that students' IEPs enable the student to make progress appropriate in light of his circumstances. If his or her circumstances are that they have problem behaviors, we need to address those. If we don't, our IEPs, how can we make progress? Which is the new standard of the new Endrew standard. Now, remember that, and remember this too. The Supreme Court did refer to academic and functional advancement. So there we go back to the old definition that all of a sudden we see, or term we see coming up in 2004 is functional needs. We have to address functional needs too. And the Supreme Court said, if we don't focus on progress, that would do little to remedy the pervasive and tragic academic stagnation that prompted Congress to act. The idea demands more. Now, one of the things I do in South Carolina is I've been a due process hearing officer in the state for 10 years, and now we have what's called a two-tier system where if you go to the local school district, if you have a due process hearing there, the hearing is actually held usually right at the school. And you have your hearing officer, you have your attorneys, you have witnesses, you have evidence introduced, and if the losing party wants, they can appeal to the next higher level, which is in our state, not in your state, but in South Carolina, it's the state level hearing officer. I'm a state level hearing officer now, so I don't actually conduct the hearings anymore. What I do is just gather, if I have a case, I'll gather boxes of evidence and transcripts and just read them and either affirm or overturn the decision of the hearing officer. Now in Indiana, under Article 7, you don't do that. You have a state level hearing officer. So it's a due process, goes right to the state, and then they can appeal to the district court. Now, the important thing is about this is about 4 months before the Endrew case, I had a state level review of a FAPE case. And so I had to use the old standard, which was really low. But still, the school had done such a horrible job. I overturned hearing officer's decision, because what I found is in their IEP, the school district had listed a need of the child had math needs. They listed it in the present levels, but they didn't have it anyplace else in the IEP. There's no goals on math, no objectives on math, no services on math, so they had an internally inconsistent IEP. So clearly, that didn't provide FAPE, even under this low standard. But now think we have this new standard that says progress. That it's a different, it's going to be a different game for hearing officers now and judges. But one very important thing is the Endrew decision said something about the role of the courts. And as a hearing officer, anytime I heard a FAPE case, I had to go by the Rowley decision, because that was the Supreme Court's. If I get home next week and there's a case that I have to hear on FAPE, I'll use the new Endrew standard. So I'll have to look at, was the IEP reasonably calculated to enable a child to make progress? Well, this is an interesting thing. One of the things the Supreme Court also said, that a reviewing court, or by extension, a hearing officer may fairly expect those authorities to be able to offer a cogent and responsive explanation for their decisions that shows the IEP is reasonably calculated to enable the child to make progress appropriate in light of his or her circumstances. In other words, I could expect if I was still doing hearings on the local level, I might call up the special ed director and I'd say, okay, tell me how your IEP addressed John's behavior and how this IEP is calculated so that John can make behavioral progress. That's a legitimate question that we could ask now. So, that's really an important thing to understand, that we have to be able to not only include in the IEP behavioral programming and make certain it's implemented as written, but we also have to be able to justify it now. Now, there was a case we talked about yesterday. I'm not going to talk about it at all today. It's a case called Oberti out of the Third Circuit. It was actually an LRE case, but Raphael Oberti had problem behaviors. And one of the things that happened in this case is that at the hearing level, or I mean in the district court level, the school district special ed director was called up in the stand to talk about how did they address Raphael's problem behavior. And what they said is, well, we had an assessment done, we had a behavior intervention plan, we implemented as written, and she was telling all these wonderful things about the plan, and the attorney, when he went to cross-examine her, said, well, I'm happy to hear about this programming, but where is it? It's not in the IEP. Where is it? And her answer boiled down was essentially, take it from us. We had a good program. You think that flew at the district court? Of course not. They are not going to go by someone's word. They're going to look at the IEP, and there was nothing in Raphael's IEP that indicated at all that they had addressed his behavior. So it's very important, especially under this new standard, that we are aware of that. So how can we make certain that our IEPs are reasonably calculated to enable a student to make progress? Well, number one recommendation I would say is make certain that when we develop the content of a student's IEP and subsequently review and revise it, we need to make sure the present levels of academic achievement and functional performance and annual goals are based on not only academics, but behavior problems. If there are problem behaviors that impedes the child's learning or that of others, that needs to be addressed in the IEP. And our information that we collect needs to be current. And this is probably one of my favorite quotes from the Endrew decision. The IEP is not a form document. It is constructed only after careful consideration of the child's present levels of achievement, disability, and potential for growth. In other words, by saying it's not a form document, that's really what guides our instruction. That's not something to write and stick in the drawer somewhere. That guides our instruction. That is the proof, that's the blueprint of a FAPE. If a child has problem behaviors and we don't address it, we may as well stamp the IEP does not provide FAPE, because that is an extraordinarily important need, as shown by, as Endrew went back down the system, Douglas County School didn't address behavior. And that was really what led, one of the major factors that led to the decision to overturn. Now, there's a couple of, and I just want to put up a couple of quotes from majority opinions and in cases, because they're very instructive. There was a case, and this was regarding a child. It was Robert Kirby was his name. It was a case called Kirby v. Cabell County Board of Education out of West Virginia. A school's IEP was determined not to provide FAPE solely on the fact that the present levels weren't done correctly. And this is what the judge wrote. If the IEP fails to assess the child's present levels of academic achievement and functional performance, the IEP does not comply with the idea. This deficiency goes to the heart of the IEP. The child's level of academic achievement and functional performance is the foundation on which the IEP must be built. Without a clear identification of the child's present levels, the IEP team cannot set measurable goals, evaluate the child's progress, and determine which educational and related services are needed. So, and so important that we understand that the present level statements are in essence the baseline, the foundation of our IEPs. If we don't get those right, this court and many others have said everything else will fall apart. It's kind of like a house. If you have the house built on a bad foundation, it's probably going to crumble and fall sooner or later. And that's exactly what this judge said. It's the foundation on which the IEP is built. So therefore, if we find problem behaviors, we have to address them in the IEP. Now, we have to remember also to address those functional needs, such as behavior. This was a decision, again, out of West Virginia in 2000, way before Endrew, that an IEP was determined not to provide FAPE because the child's IEP did not address his problem behavior. And again, he wasn't a child with emotional behavioral disorders, but he did have problem behavior. And from the decision, the judge wrote, regular grading and advancement systems are useful. That model becomes less useful in the context of a child with autism or similar disability. The concept of educational benefit must embrace more than academic subjects. The court must examine the IEP to determine whether it is reasonably calculated to provide benefit in academic areas and non-traditional areas critical to the child's education. Therefore, behavior, very important. And this was, by the way, Robert Kirby was a child with autism who also had some pretty significant problem behavior. Now, here's an important thing. This comes from the IDEA regulations written in 1997. A superintendent of schools in Ohio, I think it was, wrote one of these letters to the U.S. Department of Education, and they answered back in actually a question-answer format in the 1997 regulations. And what he said is, what's the relationship between the present levels and the goals and the services that you offer? And what the U.S. Department replied in the following way. There should be a direct relationship between the present levels of performance and other components of the IEP. Thus, if the present level statement describes a problem with the child's reading level and points to a deficiency in reading skills, the problem should be addressed under both goals and specific special ed and related services provided to the child. So just substitute deficiency or problem behavior for deficiency in reading. If you have identified a problem in the present levels, and you need to address it at other places in the IEP, such as the goals and the special ed services. And if you don't, to the extent that you have something like behavior in your present levels that you do not address, you have an internally inconsistent IEP because you have a need that's not addressed. And if you have that, you do not provide FAPE. Very important. Now, the reasonably calculated qualification, this is kind of an important thing too, reflects the recognition, this is from the Supreme Court, reflects the recognition that crafting an appropriate program requires a prospective judgment by IET members informed by their own expertise and the views of the child's parents. So in other words, what our task is to develop an IEP that we as experts, as educators, determine will enable the child to progress. But it's a prospective judgment. We can't say a child is absolutely going to meet these goals, and it's not important anyway, because in the sense that if we deliver all the services we say we would deliver, the goals are not, they're a projection of where we think the child will be and progress to in 1 year, but it's not a guarantee of success. It's a guarantee we're going to do our best, make our good faith efforts, and we're going to reasonably calculate that IEP to actually have the child make progress. And that kind of leads to the second recommendation, that we have to ensure that all our academic and functional IEP goals are challenging, and these are words from the Supreme Court, challenging, appropriately ambitious, and measurable. We don't have to worry about, and I'll tell you about a case in a little while, we don't have to worry about being too ambitious. Schools have never lost because their goals were too ambitious. They lose when their goals are not ambitious enough. Now, this is from the specific Supreme Court decision. Child's educational program must be appropriately ambitious in light of his circumstances, just as advancement from grade to grade is appropriately ambitious for children in the regular classroom. We have children in our classrooms or in special ed, their goals are going to be different. But every child should have the chance to meet challenging objectives. Now, and as I said before, a reviewing court could call the special ed director up on the stand or a hearing officer and say, what's your explanation for this IEP? How is this reasonably calculated to enable a child to progress with respect to their problem behavior? Now, we had a case out of South Carolina, went all the way to the Supreme Court. It was called Carter v. Florence. In 1991, it was a FAPE case that was heard in Columbia, South Carolina, involved a young girl named Shannon Carter. And the school district, and they did so many errors, it was painful to read the kind of things that they had done. But one of the things they did is they wrote an IEP for Shannon. She was in 9th grade. She just entering Timmonsville High School in Florence, which is a poor little area of South Carolina. They wrote an IEP for her, reading at a 4th grade level, that called for, I think it was 3 months growth in 1 year's time. And she was a bright kid. She asked her parents, just like Andrew, pulled her out, put in a private school for kids with reading problems, and she did really well. And the parents went back then and sued for tuition reimbursement. One of the major reasons the school district lost is because the IEP goals, the judge said they were so unambitious that they rendered the IEP, well, his terminology was cool, I can't remember. Oh, inadequate at inception. He said the IEP was inadequate the moment those goals were written because they were so low that if Shannon met them, it would have been so what? She's still falling further and further behind her peers. And he said the stated progress in Shannon's goals in reading and math skills for an entire school year ensured the IEP's inadequacy from its inception. Even if Shannon had met her goals, she would continue to fall further behind her peers. The goals were wholly inadequate. Florence County 4 district failed to provide Shannon Carter with a free, appropriate public education. So they wound up paying tuition at Trident Academy for 4 years plus attorney's fees, about $1 million. Just because the goals were so unambitious that they wouldn't have led to any improvement anyway. And again, if Shannon had reasonably ambitious goals and not met them, that wouldn't have been a problem. The problem was the goals were so unambitious. So I always say, err on the side of ambition. You know, I mean, you don't want to go to the moon and say Shannon is at a 4th grade level and will be reading by 12th grade by the end of the year. But you've got to do a little better than 3 months growth in 1 year's time, especially when the student has already been shown to be able to show more growth than that. So here's another from Endrew. Remember his IEP just carried the same goals forward year after year after year. Barbara Bateman has said you might as well stamp does not deliver FAPE on the top of your IEP if you're using the same goals over and over and over again. As such, that's like proof the district was not successful in creating an educational program reasonably calculated to enable Endrew to make progress. Now, another thing about, and this is a little more, this is certainly more difficult with behavior, but we have to figure out a way to measure growth toward behavior. And there are many ways we can do this, but just saying, like, this was out of a case out of New Mexico, heard at the State Department. It was actually a hearing officer, a hearing review board at the state level, overturned 2 years of IEPs because he said the goals aren't measurable. Students' annual goals in each IEP simply don't contain objective criteria which permit measurement of student progress. And this IEP would have things like increased reading comprehension, improved behavior, improved decoding skills. But according to the court, or the review officers, that open-ended statement did not represent a measurable goal. There was no way you could see if the child had met those goals by the way they were written. So that's important too. We have to write goals in ways that are measurable. They have to be ambitious. And the recommendation 3 is we have to continuously monitor and measure a child's progress and annual goals and objectives, benchmarks if applicable, and maintain specific data to demonstrate that progress has been made. Now, one of the things we talked about yesterday in our Endrew presentation is so important that if we want to show our IEPs actually benefit a child, or a child actually makes progress, or that we're intending our IEP is calculated to enable a child to make progress, how can we show that if we don't have a way to measure progress toward a child's goals? That's why the measurable aspect is so important. And that's why in 2004, Congress said we have to monitor, not only do we have to monitor students' progress, but we have to report to parents frequently on how a child is progressing. And back in 2004, Congress said, and I think maybe Article 7 still said this, we have to report to students' parents as frequently as regular ed kids get their report cards. And so that means we've got to monitor progress and we have to report to parents. It's important we think about how do we justify. Because remember what Endrew said about the cogent and responsive explanation. One of the ways we have found, I have found in reading court cases, is not a good way to say justify student progress is to say we're going to measure it by teacher observation. Now it's one thing if we're a speech and language clinician, which obviously is going to use their observations a lot, but if they have checklists and things like that. But the problem is, and this court summed it up real well, although a subjective teacher observation provides valuable information, teacher observation is not an adequate method of monitoring student progress. Without supporting data, teacher observation is opinion that cannot be verified. So teacher observation is important, but we really need to have data to show progress. If we don't have a good baseline, and we don't have a method of collecting data, how can we possibly show that our IEP is reasonably calculated to enable a student to make progress appropriate in light of their circumstances? Now, what the U.S. Department of Education has said about the importance of revising an IEP when a student is not making progress. If a child's not making expected progress toward his or her annual goals, the IEP team must revise as appropriate the IEP to address the lack of progress. Monitoring and reporting, very important. Kathleen Mayfound, who is, I think she's close to retirement. She was an attorney with a company out of Pennsylvania called Reed & Smith, which is a company that exclusively represents school districts. And what she had said is, she's a consultant also to legal research publications. When she has a potential FAPE case, first thing she says I do, when I have a school district with a FAPE case, the first thing I do is go to the teacher and say, give me information on your student's progress. If the teacher doesn't have data, I advise the school district to settle. And she's a person that represents school districts, saying that if we don't have data, we don't have any way to show progress. We don't have any way to show that our IEPs are reasonably calculated to enable progress. And that was in 2015. That was before the Endrew decision that said progress is the new watchword of FAPE. So it's very important. And what, kind of to sum up, the U.S. Department of Education, 2016, on this Dear Colleague letter I told you about, and I'll send it to anybody who's interested, said there's a number of things we really need to avoid in kids' IEPs. And this applies to any disability, regardless of what it may be. It doesn't have to be EBD or emotional behavioral disorders, any disability. Number one, the IEP team fails to include positive behavioral interventions and supports, even though a student exhibits behaviors that interfere with his learning or the learning of others. And again, I've read a number of hearings that have been decided against school districts because they just use punitive special ed services in their IEP to address behavior. Because what the law says is positive behavior interventions and supports. Second major area things we want to avoid. School officials failed to schedule an IEP review meeting to address the student's behavioral concerns after a reasonable parental request. So if a parent expresses concern, asks for an IEP meeting, you have to have it. 3, an IEP team fails to discuss a parent's concerns about their child's behavior during his or her IEP meeting. If it's a concern, you have to address it. If a teacher brings it up, if a parent brings it up, you have to address it. Doesn't mean you're going to actually have something in the IEP, but it means you have to address it. And a kind of a silly example of that is a number of years ago in Minnesota, a parent came to an IEP meeting and said, my child is having problems learning to communicate, and what I would like you to do is send my child to Florida to swim with dolphins. They found on the internet this program about kids swimming with dolphins, and they literally wanted that in the IEP. Well, you know, the chances are not so great unless maybe they took the special ed director along with them. But the IEP said no. I mean, the IEP team said no. And that's fine. I mean, of course no. But they discussed it. You have to discuss it, no matter how kind of out there it seems. Now, 4, the IEP team fails to include behavioral interventions and supports in a student's IEP, even though the team determines that student needs behavioral supports. So certainly, if the team knows a kid has problem behaviors, you better be addressing it in the IEP. More things to avoid. The IEP teams includes behavioral supports in the IEP that are inappropriate. In other words, and that usually means kind of more your punitive, negative sorts of behavioral supports are not appropriate and are used anyway. Next one, the behavioral supports in IEP are appropriate but not being implemented or implemented correctly. Teachers are not trained to implement. That's a very important issue. Think about that Withers case I was talking about. If it's in the IEP, you have to implement. In fact, there have been cases, FAPE cases, in which a school has followed the procedures and actually written an IEP that really conferred benefit, but lost at the FAPE level because they didn't implement important parts of the IEP. So you have to make sure you do that. Teachers are using behavioral procedures with a student that are not in his or IEP and are not appropriate. Student is disciplined repeatedly for problem behavior, but the IEP doesn't address it. Or student doesn't make progress toward his annual goals because of lack of support. All these things, these areas brought up by the U.S. Department of Education could result in the denial of FAPE. Thus, it's extremely important, even more important, after the final results of the Endrew decision, that if a child has problem behaviors that interferes with their learning or the learning of others, it's not enough just to consider that. We have to act. We have to react, put it in the IEP, make certain it's implemented as written. So it's about time. We have to have a little time for questions or comments. So if anybody had any questions, by the way, you can always email me, and I have all these Dear Colleague letters, and Department of Education put out this question, FAQ on Endrew. It's very interesting. I'd be glad to email anybody whatever you request. So, but if you have any questions, we have a couple minutes left. No questions? Well, thank you very much for coming, and enjoy the rest of the conference. You're intrepid conference goers, going all the way through to the end. So thank you very much.